Consider, by way of contrast, Sweden's legal principle of Allemansretten. As a rule of property access, it is directly at odds with the open fields doctrine. It creates a whole class of private property that the public can roam through, but that the government does not have a right to search. Privately owned forests, for example, are open to the public for hiking, camping, and even foraging, but the Swedish government may not search them without a warrant. There's an explanation for these different rules, but it isn't logical, it's historical. In the Middle Ages, Swedish and British commoners held customary rights that allowed them to treat some property held by the feudal lord as if it belonged to everyone. You could usually walk through a lord's forest, for example, without any problem. But then in the 18th and 19th centuries, capitalism swept through England in the form of the Enclosure Acts, ruthlessly putting an end to those rights for British peasants. As a result, British common law, and by extension American law, created a much more rigid division between private and public property than we find in Sweden. The open field doctrine is simply Anglo states having to create some legal wiggle room within that division,